Well, good morning. As Kentucky's Attorney General, it's my job to defend the rights of the good people of the Commonwealth. Part of defending their rights is giving them the open, honest, and transparent government that they deserve. We can only create that government by ensuring our elections are clean and fair and that everyone has the opportunity to exercise their constitutional rights to vote and participate. Last month, I announced another step that this office is taking to make sure those rights are upheld. I was joined by the NAACP of Louisville, the Louisville Urban League, and the League of Women Voters in support of a new section of my office dedicated to preserving voters' rights. And today, we again work towards fair elections. Today's random election audit drawing we perform helps ensure that every vote counts. In this election cycle, my office received 318 complaints from 78 counties, and 71 complaints are still under review as we sit here today by the Department of Criminal Investigations. That compares to 119 complaints from 2016. All complaints that did not involve criminal allegations have already been shared with the State Board of Elections to facilitate future trainings of county clerks and other election officials. Following the 2016 general election, Callaway, Carter, Jackson, Leslie, Muhlenberg, and Wayne counties were randomly chosen for audits. No issues or irregularities were found, and these counties may not be audited again for the May primary election. If they are chosen, they will be discarded and another county will be randomly selected. Once the 6 counties are drawn today, the proper notifications will be made to local officials and other concerned parties. The counties will be assigned with an investigator from our Department of Criminal Investigations who will begin their audit. The DCI investigator will interview local officials, random election officers, and others. They will review the precinct sheriff reports, election reports, voter assistance forms, absentee ballot applications, and many other documents. Then, they will randomly call voters who voted absentee to validate that documentation. After these audits are completed, they will be presented to the local grand juries of these 6 counties. So I'm going to be assisted today by Adrienne Willis. We appreciate your help. All right. Our first county is Scott. Our second county is Bullitt. Our third county is Powell. Our fourth county is Jessamine. Our fifth county is Rowan. And our sixth, and provided it is not one from the last election, and final county is Owen. So that is the counties that have been randomly drawn for the election audits are Scott, Bullitt, Powell, Jefferson, Rowan, and Owen. Jessamine. I didn't say that. And Jessamine. Let me try that again. The counties selected for the election audits are Scott, Bullitt, Powell, Jessamine, Rowan, and Owen counties. So I am now certifying that I drew the following counties at random to be audited pursuant to KRS 15.243 for any potential irregularities during the May 2018 primary election. All right. Thank you, Adrienne.
Thank you.
All right. Any questions?
The complaints that you received in 78 counties previously, were they in a pattern? Were there a certain type of charge that was being made?
We have broken down on the website from the overall complaints by each county and what type of complaint that was made. That's on the ag.ky.gov website. We cannot identify which ones of those are still active because, for instance, in some counties there may only be one, and in the end we don't want the folks that there has been any activity alleged against to know that we're investigating them.
How many of those complaints did you find had merit, like that they were actually valid?
During the last general election, we've closed all complaints without any further action. If you go back to the primary election before that, we had a conviction in Pike County for the individual who basically shut down a polling location.
I believe your office received a letter yesterday from some Democratic representatives who wanted to know why some protesters weren't allowed into the Capitol on Monday. Have you got that letter, and what's your response?
Well, that letter requests an official legal opinion from the Attorney General's office, and so we'll begin work on that opinion. Because an official opinion's been requested, I don't think it's appropriate to comment on the law at this standpoint. I'd just say that if it was up to me and I was making a decision when the people come to the Capitol, they'd be allowed in the Capitol.
I got a question that you've heard before. Are you running for governor in 2019?
Well, right now we're focused on ensuring that these last set of elections were fair so that we can ensure that the next sets of elections are fair. And I'm still preparing for what I believe is a pretty big argument on the pension matter, and that's my sole focus at the moment.
Yeah,
You see that being delayed?
That is ultimately in the hands of the Chief Justice and the Circuit Judge, and I'll be awaiting to see if we hear anything, for instance, today from them.
Is that a possibility today, or do these type of requests normally take several days, weeks?
This type of request is one that is extremely rare, and for a party to have already engaged in 2 months of litigation, to have already asked a judge for certain rulings, and then when they did not go their way, suddenly say, oh, wait, we think there are grounds that you shouldn't be the judge anymore. That's very rare. And one could suggest that it's even waived, your ability to make these requests. It suggests judicial or judge shopping. And if you're not getting the results that you want early on, try to get a new judge. And I don't think that's allowed.
What do you think about their argument that it needs to be a judge that is not in the judicial retirement system, or was in the judicial retirement system after 2013?
Well, I think their argument is based on a theory that would allow this governor to ultimately appoint the Supreme Court that would hear his argument, which would break down our entire form of democracy where we have separate branches of government.
Is this a rule of necessity, I believe? Is that what they call it?
This is basically all that what we're seeing here is a significant disrespect for our entire judicial system. It is a co-equal branch of government who, under the Constitution, is responsible, has a duty for identifying unconstitutionally passed laws and voiding them. All the judiciary is trying to do here is its job, and it shouldn't be attacked by another branch of government just for doing its job.
You think the governor is trying to delay this case?
Yes.
Can you expand? I mean, why do you think that a delay would even be helpful to him?
We've got 200,000 public servants whose constitutional rights have been violated. And those 200,000 public servants who are police officers, firefighters, teachers, custodians, bus drivers, librarians, both they and their families are anxious. Some of them are trying to make decisions of, do I go ahead and retire now? And they're upset because they've been disrespected. And when the General Assembly tried to do this in a transparent way with Senate Bill 1, when they tried to follow the rules, it was defeated. When the public were allowed to have comment and participation in the process in Senate Bill 1, it was defeated. So what did the legislature do? It went around the people. And it turned a 11-page sewer bill into a 291-page pension bill and passed it in less than 6 hours. So people are upset, and they deserve a quick and final ruling because at least some of the provisions will go into effect in July. And I think out of respect for those families, we ought to have that decision.
Just got to have those state employees on pins and needles, since a lot of them, August is a big retirement month.
That's right, and we have seen spikes in retirement.
So hold on, you said why you think it should be heard quickly, but you didn't say why the governor might want to delay. Why do you think the governor might want to delay?
Well, I think it's obvious that the governor is trying to delay or even prevent a ruling. First he tried to get rid of me, and that didn't work. Then he tried to slow things down by getting to depose me or teachers or firefighters. That didn't work. Then he tried to get rid of the judge in one way, and that didn't work. And now he's trying again. If your legal arguments are strong, you're not afraid of getting a ruling. If your legal arguments are wrong, you're ready to go to court and make the argument. In the end, I believe that the actions of the General Assembly and that the arguments of the governor are unconstitutional. And at some level, they know it. And so to prevent or delay, I think, is the tactic that they're engaged in. And again, I think it's disrespectful because we've got 200,000 families and individuals out there that deserve this ruling. We're supposed to be a government of the people.
You, I think, issued a news release or a statement recently about Martin County.
Yes.
The water system. So you're going to be launching an investigation of them or review? What are your concerns there?
We've launched an inquiry. The situation in Martin County with the water district is a very serious situation. The people there are being significantly affected. The reasons why the situation has gotten as bad as it is need to be out there for the people of Martin County and Kentucky to understand. But also we need to ensure that going forward, that dollars are spent correctly, that if dollars are put towards fixing the problem, they go towards fixing the problem. And there are other groups that are involved in trying to rectify this situation, and we hope to be able to work with them. While our inquiry will be independent, for instance, of the PSC hearings, our hope is that the information that we acquire can be used in those hearings. In the end, we want what all the citizens that are served by the water district want is a functioning utility that can provide water at a price that the people can afford.
Will this be just a fact-finding report, or do you potentially have criminal charges?
We'll go where the evidence takes us. We'll go where the information takes us. We don't want to prejudge the situation, but we do want to get to the bottom of it.
So until you hear otherwise, you're preparing to state your case tomorrow?
Absolutely.
Will you seek, is part of it going to be to keep the law from going into effect, a restraining order or injunction?
Our argument is that both the way the bill was passed and its contents are unconstitutional. And if a judge were to find that the way it was passed was unconstitutional, it would void the bill so it would not go into effect. A ruling of unconstitutionality would prevent it from going into effect.
Any update on your opioid lawsuits? Are we still in the stages of those?
Well, they are continuing. We recently argued the Endo case in court on a motion to dismiss by Endo. And let me tell you, Endo's argument was pretty offensive. It was that they don't have any responsibility whatsoever as it relates to the opioid crisis. And this is a group that made two products, Opana and Opana ER, that are some of the most dangerous addictive opioids that are out there. And their argument even suggested that everyone knew the dangers of their drugs. And in their words, we did this to ourselves. I think that, again, that is offensive, and it is exactly why we're pursuing these companies. Most of the other companies that the process is moving on have tried to first remove from state court to federal court and then to potentially move it to the multi-district litigation. We are pushing to have them returned to state court. I believe we have an argument upcoming in front of the panel that does those transfers, and then potentially would have an argument in front of the judge who sits over all those cases that have been consolidated.
Anything else, guys?
All right. Thank you very much.